This video will concisely outline the main facts and holdings in Grant and Commissioner of Patents 2006. The appellant, Mr. Grant, sought to gain patentability for a method of structuring a financial transaction to protect an individual's assets from a loss of ownership resulting from legal liability. The Deputy Commissioner of Patents revoked the claimed innovation patent due to the fact that there was no manner of manufacture within the meaning of Section 6 of the Statute of Monopolies 1623. This is an appeal case to the decision made by the Federal Court of Australia, where Justice Branson upheld the decision made by the Deputy Commissioner of Patents. Under Section 18(1)(a) of the Patents Act 1990, it is a requirement for a patentable invention for the purposes of an innovation patent that it is a manner of manufacture. The Deputy Commissioner came to the conclusion that the invention did not result in an artificially created state of affairs and was not a manner of manufacture. Mr. Grant argued that his proposed invention is a business system, as indicated by the report on a review of the patenting of business systems, which was written by the Advisory Council on Intellectual Property. In response to this report, the government was in favour of the patentability of business systems. However, the court quickly rejected this contention as it was not relevant to the scope of patent protection. Mr. Grant also contended that his invention was a manner of manufacture based on the reasoning of the High Court in National Research Development Corporation and Commissioner of Patents 1959. The case formed the basis for determining what is patentable, setting the scope of what is protected by Section 6 of the Statute of Monopolies. Furthermore, it was established that the new inventions and technological advancements should not be hindered by contrived legal constraints. Mr. Grant argued that the invention provided economic utility and that it created an artificial state of affairs within the meaning set out by the NRDC case. Moreover, he implored that the Deputy Commissioner wrongly applied the NRDC case in a rigid and formulaic manner rather than flexibly. Additionally, Mr. Grant claimed that Wellcome Real-Time SA and Catuity Inc. 2001 applied to his case as it established that a device or the application of technology was not required. Despite these contentions, Justices Heery, Keifel and Bennett upheld the court's decision to dismiss the appeal and revoke the innovation patent. Prima facie, the appellant's scheme was clearly not patentable as it required no physical component and produced no physical effect. However, due to the fact that the invention produced an artificially created state of affairs of economic utility, it was necessary for the court to precisely define the limits of manner of manufacture as justification for eventually deeming the scheme unpatentable. The court indicated that as found in NRDC, it was required that an observable alteration or creation resulted from a physical phenomenon. That is, a concrete effect or phenomenon or manifestation or transformation. It was held that the proposed scheme did not satisfy this test as it did not produce any of those things. The new invention was deemed to have merely represented a new use of known products, which is not the proper subject of letters patent. Conclusively, the court held that due to the fact that mere schemes, abstract ideas, or legal advices are not patentable, Mr. Grant's appeal would be dismissed.